want to bring in some other legal experts to talk about what we're learning right now. Ellie Honig and Misty Marris. Ellie, so after all this, the jury has finished deliberations for the day. They're going to come back tomorrow. What happens tomorrow? Will we have a verdict tomorrow?
Okay, Jake, I've been in this exact situation in this exact courtroom where you have a partial verdict, you don't know what it is. A couple things that the prosecutors are looking at. Number one, they know the jury has verdicts, has not hung on counts 2 through 5. Of course, they don't know what those verdicts are, but that's good news if you're a prosecutor because the hung jury is always a nightmare for prosecutors. It's basically a win for the defense. The other thing, if we look at the wording of the note that came out, it tells us that there are multiple jurors on either side. It uses the plural of count 1, the racketeering count. Now, here's what's going to happen tomorrow. The jury will come back in. They will resume deliberations on count 1, on the racketeering count, and one of two things will happen from there. Either A, they will come back and say, okay, Judge, now we've reached a verdict on count 1. That happens sometimes. I wouldn't say often, but sometimes, in which case we'll have verdicts on all 5 counts. Jury will come out and tell us what the verdicts are on counts 1 through 5. The other option, which is slightly more common in my experience, is the jury will come back at some point tomorrow and say, Judge, you know, we tried again, we listened to your instruction, we kept open minds, we debated it 3 more hours, 4 more hours, and we're still stuck. And at that point, what the judge is likely to do and has the power to do is say, fine, come in, I'm going to take your verdicts on counts 2 through 5, and we're going to declare count 1 a hung jury, a mistrial. So that's what we're looking for tomorrow.
So, Misty, let me ask you this because this is some more legal language that I'm not all that familiar with. The government, the prosecution, asked for a modified Allen charge. The defense said it's too early for that. What does that mean?
So an Allen charge is what we call a dynamite charge. It's when the judge instructs the jury to go back into that jury room and not to give up on their convictions or change their mind because of coercion or pressure, but to listen to the people that are in the majority. So those that are in the minority, listen to those in the majority, keep an open mind, and try and come to a consensus. So an Allen charge, it's statutory language. It's like a boilerplate charge. And what the judge actually, what it sounds like the judge read was some modification of a formal Allen charge. But the Allen charge, the reason they call it the dynamite charge is it's generally that last-ditch effort to get the jury to come to a consensus. And there's an analysis about it because you don't want an issue where the jury has felt pressure to change their mind. And that's why the language is really consistent here in the Second Circuit. There's specific language that the judge would read. And what we heard or what we is reported that the judge did is a modification of that charge.
All right, Misty and Ellie, stick around.